Hello, everybody, and welcome to History Bite number 100, dated November 1st, 2020. I'm Walter, your mobile historian and blue-collar scholar. This History Bite is entitled Federal Court Subject Matter Jurisdiction. Before I begin, I would like to add my disclaimer that I am not a licensed attorney and that nothing that is said in this or any other History Bite should be construed as legal advice to follow in any legal situation. For proper information regarding how to solve a legal issue, problem, or dispute of any kind, please seek the advice of a qualified attorney. Thank you very much. To continue, subject matter jurisdiction, simply put, is the authority of a court, to decide and pass judgment upon the subject matter in a given case. Without that jurisdiction, the court cannot pass judgment upon it, right? Exactly. So, the federal judiciary exercises three primary types of subject matter jurisdiction, and they are as follows: federal question jurisdiction, diversity jurisdiction, and supplemental jurisdiction. I'll talk a little bit about each so that you can understand how they operate, in their own respective spheres. Number one, federal question jurisdiction. This type of jurisdiction comes into play whenever anyone initiates a case of any kind based upon the Constitution or laws of the United States or under a U.S. treaty of some kind, Anytime there is a federal question presented under the Constitution, federal laws, or a U.S. treaty, federal question jurisdiction can be invoked, Federal question jurisdiction draws its authority directly from Article 3 of the Constitution, which reads that the judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States and treaties made, or which shall be made under their authority. So if you have a case, you have an issue, dispute arising under the U.S. Constitution, relevant federal law, or U.S. treaty, the federal court can hear your case under its federal question jurisdiction. Quite simple, Arguably, this is the broadest avenue to be able to initiate a case in federal court, as it does not have the stipulations attached to it, like diversity, for example, which we'll get to next, So an example of federal question jurisdiction, is as follows. Let's say an African-American man traveling from Maryland down to Virginia arrives at his destination in Richmond and tries to check into a hotel, but is told by the clerk at the front counter that this hotel does not accept African-Americans, That individual would then, in all likelihood, be able to initiate a lawsuit under Title II of the Civil Rights Act of 1964, which clearly prohibits discrimination in public accommodations, So, obviously, the federal question jurisdiction comes into play because the Civil Rights Act of 1964 is a relevant federal law, And he would logically be able to initiate a suit under that law, which prohibits, accommodation discrimination, So, that is federal question jurisdiction, Any cases arising under the Constitution, federal laws, or U.S. treaties, Federal question. Next type of jurisdiction is diversity jurisdiction. Diversity jurisdiction occurs when the plaintiff and defendant or defendants, live in different states, Let's say, for example, the plaintiff lives in Massachusetts and the defendant lives in New York, In this circumstance, there is a diversity of the jurisdictions involved, hence why it is called diversity. The type of case is known as diversity cases. Diversity cases, can then be heard in federal court as long as these two individuals live in separate states, plaintiff in Massachusetts, for example, defendant in New York, and the amount in controversy exceeds $75,000, So the plaintiff in Massachusetts is suing the defendant in New York for an amount greater than $75,000. Let's say he's suing him for $1 million. Fine, doesn't make a difference. But if he's suing him for $65,000, guess what? The case is going to be remanded to the appropriate state court. But the federal court would not be able to hear it under its diversity jurisdiction. Diversity jurisdiction is set under volume 28 of the U.S. Code, section 1332, that amount in controversy must be greater than $75,000. If it's not, the matter will be remanded to state court. They will adjudicate it, not the federal court, because it will lack the jurisdiction. Okay? And last but not least, the diversity must be complete. So let's say, for example, the plaintiff in Massachusetts decides to not only sue that defendant in New York, but he also decides to sue a defendant in Connecticut and another defendant in Massachusetts. Well, guess what? He just got his case thrown out. Why? Because the federal court would not have the authority to hear that, because the diversity is not complete. If the plaintiff and any other defendant involved, okay, live in the same state, in this case, clearly one of the defendants lived in Massachusetts as well, then guess what? The diversity is not complete, and the federal court will not have jurisdiction over it. It will be tossed out, all right? It cannot hear a case. No court, not even the U.S. Supreme Court, can hear a case that falls outside of its jurisdiction. So if the court does not have jurisdiction to hear it, cannot hear it. So real quick again with diversity, all right, the plaintiff and the defendant live in separate states, all right? The amount the plaintiff is suing the defendant for, also known as the amount in controversy, has to be greater than $75,000, okay? Greater, all right? Theoretically not at or lower. It has to be greater, right? And last but not least, the diversity has to be complete. If there's more than one defendant involved, okay, under no circumstance can any of the defendants live in the same state as the plaintiff. If they do, the diversity is not complete, and the federal court does not possess the jurisdiction to hear the case. All right? So that's diversity jurisdiction. And last but not least, we have supplemental jurisdiction. Supplemental jurisdiction essentially is exercised when a federal court hears a case involving a legal dispute or a matter that would typically be heard in the state courts. However, this dispute is very, very, very closely linked and tied to, all right, the predominant issue that the court is deciding, all right? And so even though it is a matter that typically would fall under state authority to decide in the state courts, because it's so closely tied to the, let's say, the case that the U.S. District Court is deciding under its federal jurisdiction, federal question jurisdiction, it also decides the issue in dispute under its supplemental jurisdiction. Okay, if I need to further clarify that, let me explain it one more time. Supplemental jurisdiction is completely discretionary jurisdiction exercised by the federal courts, all right, when they decide a legal dispute or claim that is practically linked, okay, to another case that is pending before the court, that is awaiting judgment, all right, under, let's say, for example, the court's federal question jurisdiction, all right? So it is related to that claim under the federal question jurisdiction, and the court will exercise its supplemental jurisdiction to not only decide the case that's pending under its federal question jurisdiction, but it will also decide this basically adjacent or ancillary claim as well, okay? So to essentially dispose of the whole matter at one time. Federal court does not have to use that jurisdiction, but it may do so if it chooses to do so in the appropriate circumstance, okay? So those are the three primary types of federal court subject matter jurisdiction, all right? Real quick, once again, federal question jurisdiction, whenever someone initiates a case based on under the Constitution of the United States, federal laws, or U.S. treaty, all right? Number two, diversity jurisdiction, when you have a plaintiff and a defendant who live in different states, okay? It is known as an action in diversity, okay? The amount in controversy must be greater than $75,000, okay? And the diversity must be complete and in full, all right? If there's more than one defendant in the case, okay, under no circumstance can any of the defendants live in the same state as the plaintiff, all right? Diversity has to be complete. If any of the defendants live in the same state as the plaintiff, the federal court would not possess the authority to hear it, all right? It would have to be heard in another venue. But the diversity must be complete. The amount in controversy must be greater than $75,000, and the plaintiff and the defendant have to live in separate states, all right? So that's diversity jurisdiction. Supplemental jurisdiction occurs when the federal court, in addition to exercising and deciding a case based on either federal question jurisdiction or diversity, it also decides a claim, okay, that's related, okay, to an existing case pending before the court, all right? It's directly tied to that case. And that supplemental jurisdiction would normally be an issue decided in state court, but since it's already here and it's so closely related and basically linked to this other case that the court has yet to decide, the court ends up deciding, the federal court ends up deciding both of them, both the case, let's say, under its federal question jurisdiction as well, okay, as this supplemental jurisdiction to this additional claim, okay? So the court disposes of everything at one time, all right, rather than having that supplemental claim decided by a state court or, you know, further down the road. Gets rid of it all in one fell swoop, okay? So those are the three primary types of federal court subject matter jurisdiction, okay? If you have any questions or controversies, please leave them down below and I'll be happy to answer them. Thank you so much for listening to this History Bite. If you have not subscribed to my channel, please do so as soon as you can. I would greatly appreciate it. Take care, stay safe out there, and I'll talk to you at the next one. Peace.